All right. All right. Thanks for coming. Just to give you some background, my name is Warren, as you can see on screen, and I work in intellectual property for an IP firm called Cooper IP, based in Melbourne. And in normal circumstances, we actually do come to Tasmania for a couple of days every month, stopping by Hobart, Launceston, and Burnie, and we provide free IP consultations to startups, young businesses, established businesses, and anyone in between. But in the current circumstances, we've been very well behaved. We've been working from home, and I haven't set foot in Tasmania for about 3 months now. So thank you, Amy, and everyone at Enterprise for running this IP event for us. Hopefully we'll be able to set foot in Tasmania again soon. We like to give these kinds of presentations really to educate people about IP. We find that Australian businesses aren't that familiar with intellectual property, and it's not something most people are talking or thinking about, which is fair enough. And even if they are, there can be some pretty big misconceptions. And that can really hurt a business when it comes to protecting what they create and capturing value from what they create. So as we go through these slides, I think it'll kind of get clear that IP is really relevant when there's change. And in the context of businesses, what I mean is it's when a business is starting, it's when a business is pivoting from selling one thing to another, or if they're innovating and creating new technologies altogether. It's at these phases of change where IP can be really important to think about. And so while in normal circumstances, I already think it's important to know about the kinds of things I'm going to cover tonight, given the sort of like economic shock and almost reset that the world is going through. I think it's even more important and relevant to have all this IP information in your minds now, especially as we're seeing businesses really having to think on their feet and maybe even needing to change the way they operate. So for example, we recently worked with an Australian business that found a patented product in the US, which is receiving a lot of attention right now because it allows you to open and close doors with your foot. Which is, yeah, who thought we'd be seeing that day? So, and that Australian business wanted us to find out if there'd be any sort of patent infringement issues if they were to sell that product in Australia. We also worked with another client recently who's pretty convinced that people aren't going to go out as much to have a certain cosmetic work done to their face. So she's created this product which actually helps you keep a certain look for longer. I have to be a bit vague, but yeah, essentially we filed a patent application to protect the product and some trademark applications to protect the branding. So these are some of the more like obvious examples where businesses are pivoting or popping up to try and meet or address new demands in the market. So with all the change that's kind of happening with COVID, I think it's really important to have a good understanding about what IP is and the role it can play in a business, especially at these kinds of inflection points. So my goal tonight really is to make IP a lot more familiar to everyone and look at where things can often go wrong, so you can spot them before they happen. If you do have any questions, I don't know how many there are listening at the moment, but if it's a small group, feel free to just jump in with a question. If it's in the chat box, I can't see it when I'm sharing the screen. So Amy, you'll just let me know.
Yeah, I can do that.
Very good. So, something's not working. There we go. So here's a quick look of what we're going to go through today. I'll start off with a brief introduction of what intellectual property is, and I'll do that in the context of a real Tasmanian business. Then I'll dive into trademarks and patents. These are two of the more common IP rights that people apply for, and we'll look at where things can go wrong, because things can go wrong there. Now I'm going to just sort of issue a bit of a warning up front. This is not going to be a very general presentation. I want to go into some pretty nuanced aspects about trademarks and patents. So I just want to make sure that you have something to take away from this presentation. I know you're giving up some time at 6 p.m. on a Wednesday. And then at the end, we'll have time for some questions. But if you need to leave early, just send me a message. You can find us online at cooperip.com, and you can message or email me directly at warren@cooperip.com. So to begin, what's intellectual property? As the name suggests, it's property of the intellect. I like to think of it as it's what we create. And when people spend a lot of time and energy creating new things, new works of art, new technologies, new companies, it can be pretty unfair and even demoralizing if someone else just comes along and copies them. So over time, IP systems have been developed to give us a bit of insurance so that if people do create something new, we want to make sure it's possible for them to have some control over what they've created. So when some people think about IP, the first things that might come to mind might be patent battles between Apple and Samsung. And maybe you've even heard about the recent trademark disputes between Kraft and Bega. But it's not just these giant companies who dabble in IP. We work with a wide range of small businesses where sometimes a lot of their success comes from a handful of key products or services that they've managed to protect really well. So I want to start off just by looking at one of these businesses, and we'll see how they've used their IP to their advantage. So one business we work with is Scootboot. They're a Tasmanian business. I'm not sure if you've come across them before, but they were founded in Hobart in 2015 by these two. So that's Dave on the left and Annette on the right. And what they've done is create a high-performing boot for horses. I kind of think it looks like a bit of like Crocs for horses or something. I see there's a message in the chat box. Oh, thanks. That I don't know. I'll have to get back to you on that one. Now, I don't know if you've seen a horse boot before, but I certainly hadn't until I worked with Scootboot. It's a pretty niche product, but their boots really taken the horse riding world by storm. It replaces horseshoes. It's super comfortable to wear for horses. I've never tried them on myself, and it's pretty easy. It's very easy to put on and maintain. And at this point, Scootboot is probably the world's biggest seller of horse boots. And that's all the more impressive when you know they're just a small business operating out of Tasmania, or out of Hobart even. Now, oh, my keyboard's not working. Hang on. All right, Now, horse boots themselves aren't new. There's a very exciting range that you can find on Google Images. So I don't want you to think that Scootboot invented horse boots from the ground up, but their boot really does have a bunch of important functional advantages. So here are some views of one of their boots. Now, normally when a horse is moving, the front of their hooves ram into the front of the boot with quite a lot of force, and this can actually concuss their hooves. So to address this problem, Scootboot's made their boot's made from this relatively tough but flexible material, and they've got these two slots at the front, which you can see in this drawing on the left, so that when the hoof pushes into the front of the boot, the front of the boot actually stretches and to reduce impact against the hoof. There are a bunch of other advantages, so relating to sort of the way the boot fits to the back of the hoof, and there's these side slots, which really helps with trimming the hoof. But I won't go into sort of detail there just to save some time. But all that is to say, Scootboot's created a horse boot, which has a bunch of new functions and advantages over existing boots. And so having spent a lot of time and resources perfecting their boot, they wanted to make sure that if they brought it to market, it wasn't going to be ripped off by a competitor. And so they wanted to protect their boot as much as possible. So the first form of protection they turned to was patent protection. As you might know, patents protect inventions. And when many of us hear the word invention, we might think it's something high tech, like the bionic ear or a new drug. But In the world of patents, an invention can be anything that does something new or has a new function. So you can think of patents as being legal rights which protect new functions. Another IP right Scoop Boot used to protect their boot is what's called the registered design. Now, basically, a registered design protects the look of a product. So Scoop Boot considered the look of their product to be quite unique. And so they wanted to make sure that others couldn't copy the look of their boot either. Registered designs, they're not as popular as patents and trademarks, but they can be really important for products which don't necessarily have a new function, but have a distinctive look. So I'll give you an example of what I mean. Now, if you just look at these three black and white drawings, pretty simple, you can almost very easily guess which company makes them. These are really, relatively generic products, especially the keyboard and plug, but they do have this sort of unique Apple look. And a big part of how Apple has maintained their visual style is because they've been protecting the way their products look using registered designs. So I won't go into registered designs much more, but the take-home message here is that the appearance of a product can be protected with a registered design. So you've got patents protecting functionality on the one hand, and registered designs protecting appearance on the other. And of course, we have Scoop Boot's logo and name, which they've protected as registered trademarks. Now, Scoop Boot's come a long way since their founding in 2015. They've won the Tasmanian Telstra Business of the Year Award, the Australian Export Awards, and Dave mentioned he knew their business had made it when they saw their boots worn by US police officers, police horses at the Super Bowl. And often it can be hard to know whether copycats or competitors would have popped up at all. But at the same time, it's only when you don't protect your IP that you can get into trouble. So to drive that point home, we used to act for a large international retailer, and one of its business models was to find products which were selling really well, copy them, and then sell those products for much cheaper. And to make sure they could do that without infringing any IP, they asked us, our job was to find out, was there any IP protecting the products they wanted to copy? And if there wasn't, they'd have a field day. But if there was IP protection in place, they'd steer clear. So if I was one of those IP rights holders, I would never have known that my IP ended up protecting me. And so the value of my IP can sometimes seem or feel invisible. But in the case of Scoop Boot, we actually found out firsthand that their patents play a really important role in sort of securing their edge in the marketplace. Because it wasn't long after Scoop Boot started really taking off that a competitor actually engaged their own attorneys and started making submissions to the Australian and US patent offices, trying to challenge Scoop Boot's patent applications. So thankfully, those attempts haven't been successful, and Scoop Boot's market share has remained intact. But I thought I'd start with this quick look at Scoop Boot because I think it's a really great example of how a small Tasmanian business has really been able to thrive and carve out their niche internationally and keep their competitors at bay by actually protecting their intellectual property. So now I'm going to take a sip. I'd like to go a little deeper into trademarks and talk about the things that can go wrong. But before we get there, I just want to start off with a quick background to trademarks. So the first thing to say is that trademarks can be any type of sign which acts to tell consumers where a product or service comes from. They're often visual. They come in the form of logos, words, and phrases. And when a company gets a registered trademark, they have the exclusive right to use that trademark, which means no one else can use it in the course of trade. So when IP systems give out these kinds of exclusive trademark rights, they need to make sure others aren't going to be blocked from using common words and phrases. So for example, if I wanted to open a computer store, I shouldn't have exclusive rights to the word computer. So to make sure that doesn't happen, in order for a trademark to get registered, it needs to meet two main requirements. The first is that all trademarks have to be registered under certain goods and services. So for example, with this, so this is a Bogues trademark, which is taken off the Australian Trademarks Register. You can see it's registered in class 32, which covers beer, ale, stout, or porter. So what this means is the company has the exclusive right to use the word Bogues with these products. It doesn't mean they have the exclusive right to that word in general. The second requirement for a trademark registration is that the trademark actually needs to be distinctive. And what I mean by distinctive is they can't be words and phrases that others are likely going to want to use with their own goods and services. And if you think about sort of the most iconic trademarks in the world, they tend to have very little, if anything, to do with the goods and services they're used with. So for example, if you've never heard of these companies before and you looked at these trademarks, you'd probably have a pretty hard time guessing what they do. So for example, let's look at IKEA. This is a very distinctive trademark. It's a completely made up word. It's got nothing to do with furniture and it's registered under domestic furniture. And so even if someone has exclusive rights to the word IKEA, it doesn't stop others from coming up with other names for their furniture stores. So this is a great example of a distinctive trademark. So that's sort of the background information I wanted to get out of the way. And sort of the first trademark trap I want to touch on is basically when people pick trademarks that aren't distinctive. This can be a very common problem when it comes to businesses that might not have a lot of customers or exposure. And so they want to come up with a name that tells customers exactly what it is they do. But the result is they come up with a trademark that's really descriptive of their goods and services. So there are certain types of businesses where it can make sense to have a very descriptive trademark. So if you're like a brick and mortar store, you're not looking to expand and maybe you're only serving customers in a fixed location, like a cafe, it can make sense for these kinds of businesses to use a trademark that describes exactly what it is they do. Like you might call your cafe like Cafe on York Street or something. But for businesses that want to grow and have a reach that's beyond their physical location, if they even have a physical location, they're often better off picking a distinctive trademark. So here's an example of a company that filed a trademark application to protect the phrase Tasmania Black Angus beef as a trademark for meat and meat products. So obviously this is not a distinctive trademark, and you can see that the trademark application wasn't accepted and lapsed. And so this company's gone ahead and paid to protect the trademark. They were very unlikely to be able to register in the first place. And this is just one thing we want to help businesses avoid. Now, there are two main problems when it comes to using a non-distinctive trademark. The first is you can't register it as a trademark, obviously, so you can't get exclusive rights to it. And because of that, you're likely to run into competitors who are going to use the same trademark or trademarks that are very similar to it. And because of that, you're going to find it hard to distinguish yourself from competitors. The second problem really kind of flows on from the first, is that it's going to be difficult for customers to find you. This is especially the case for new businesses who are just not going to be found on platforms like Google. So my first tip of the night, if you want exclusive trademark rights, if you want to be found, and if you want to more easily distinguish yourself from competitors, you're better off picking a distinctive trademark. So let's say you've picked a trademark that you think is pretty distinctive. Before you actually go ahead plastering that trademark everywhere, using it in your marketing and social media, you should actually check it's free to use. Because if someone else has already registered that trademark that you've come up with, your use of that trademark or something similar to it can actually constitute trademark infringement. And the worst case scenario is when we see a business really commit to their branding without doing any clearance searching, any sort of trademark searching, so that we see their branding all over their website, it's on their products, it's all over their marketing and an Instagram account, and out of nowhere, they can get a cease and desist letter. And it's only at this point that they might seek trademark advice. But it's also at this point that there's often very little they can do besides rebranding, and that can be really painful. So one attorney we work with, he had a client who sold a range of wellness products like candles and things. And the candles, they were etched with a trademark. And after selling them for not too long in Australia, she received a cease and desist letter. And she was in tears because she still had tens of thousands of dollars worth of product that she couldn't sell. And eventually she decided to move to New Zealand to sell them because the other party didn't have trademark rights there. So all that is to say, once you've decided on the trademark, make sure you actually check it's free to use, because on the very slim off chance, maybe not even slim, but on the off chance it's not free to use, the consequences can be pretty drastic. The good news is that this kind of problem is rather easy to avoid if you know to avoid it in the first place. So the Australian Trademarks Office has an online trademarks database that's really easy to use. You can search by words, phrases, and even images. So if you've had a logo designed, you can actually upload that logo here and search to see if similar logos are already registered. So let's take a look at an example. Let's say you're a physiotherapist looking to open a clinic and you've brainstormed with a couple of trademarks and you land on back in motion, which I think is pretty clever. So all you need to do is jump on the Australian Trademarks Register and make sure it's not already taken. You type it in and, unfortunately you see someone else has already registered it. They've registered it under physiotherapy services, among other things. So while this result can be disappointing at first, it's actually saved you a lot of trouble later on. So definitely encourage you to do some trademark searching before you really commit to something. One final thing to add is that all intellectual property rights, so trademarks, patents, and designs, they operate on a per country basis. So if you're going to use your trademark in Australia, then you only need to make sure it's free to use in Australia. But if you have plans to expand overseas, you also want to make sure your trademark is free to use in those countries as well. Now, when you do your trademark searching, you might come across a number of existing trademarks that look like yours, and you might think you need to come up with something else, but that's not necessarily the case. So you'll remember all trademarks are registered under specific goods and services. So just because someone else has already registered your trademark or registered something that looks like your trademark, it doesn't mean you can't use and register yours too, provided there's no overlap in goods and services. So let's have a look at an example. Let's say you want to start a yoga studio called Happy Baby, which I think would be a great name for a yoga studio, by the way. So feel free to take that. Now, if you search for Happy Baby on the Australian Trademarks Register, you'll find 13 registered trademarks. And you might be discouraged and think, you need to pick another name. But that's not the end of the story. You need to actually look at each trademark and check what goods and services they're registered under. So if you click into the first trademark, we can see that it's registered in class 16 for bibs, which has nothing to do with yoga. And if we click into the second one, we see that it's registered under a range of medical equipment, which again has nothing to do with yoga. So provided that none of these 13 trademarks are registered under goods and services that relate to yoga, you'd actually be free to use and protect your Happy Baby trademark. So that brings me to this tip, which is when you do your trademark searching, make sure you pay attention to the goods and services that the trademarks are actually registered under. So the last trademark issue I want to touch on relates to trademarks in China. Now, China is Australia's biggest trading partner, and we do see Australian businesses wanting to tap into the Chinese market. So it's important for them to know how to manage their brand in China. Now, in most countries, including Australia, when it comes to trademarks, it's a first to use system. So what that means is, generally speaking, trademark rights belong to whoever first uses the trademark. Now, the same can't be said for China. Rather than being a first to use system, they are a first to file system, which means the owner of a trademark is the one who files for trademark protection first. So even if you've been using your trademark there, you can end up infringing someone else's later filed trademark. So this first to file system has led to a pretty terrible practice of trademark squatting. So that's where people, they file trademark applications with no intention to use them, other than to sell them off to a company that actually needs it, often for a lot of money. So this is pretty similar to the practice of domain name squatting that happened during the early days of the internet. So while the Chinese IP systems they're taking steps to combat trademark squatting, but it's still an issue to really be on top of and wary of right now. So if you have any intention of entering the Chinese market, you definitely need to be thinking about trademark protection early, and obviously definitely before selling your products and services there. So now I want to move into patents. I want to take a bit of a breather as well, because I know these Zoom webinars can be pretty tiring, especially for Rebecca, who's on her 5th one today. So I've put together some pictures of some of the wonderful inventions I've found in patents. I don't know about you, but the urinal forehead rest is probably not going to take off with all the social distancing that's happening. I'll give you a quick second to try and guess what these 2 different inventions are. So the one on the left is an automatic petting machine for your pet. And the other one on the right is a wall-mounted high-fiving machine. I could probably use that one. And let's see. Oh, this one's my favorite so far. It's a portable bath, so you can bathe on the go. All right, let's soldier on.
This makes me think people have too much time up their sleeves.
Was that an actual woman in that water bottle?
Oh, yeah.
Okay. I see. Okay.
Yeah. I really like to get into the mind of the person who had to illustrate this.
How's she going to zip that up? For starters.
I don't know how it works. I think you need a friend.
And how do you turn the hose off?
Look, I don't have answers for this.
Okay.
This is beyond my realm. Really. Yeah.
I
don't think it's
No,
the fact that we haven't. Sorry, go on.
I was just going to say, so Warren's fired and we'll find the person who created this to talk to you all. So
Yeah, I'm so sorry I can't answer more. I can send you the details afterwards if you'd like. Actually, no, I'm not going to do that. I'll take that back. Right. So before I go into where things can go wrong with patents, I want to mention 3 things just to give you some background information about how patents work. The first is that when you file a patent application, you need to include what's called a patent specification. And that's a written document which describes how your invention works. And that's kind of the deal for getting a patent. You need to share how your invention works with the public, and in return, you get a monopoly for your invention. The second thing to note is that for your invention to be granted patent protection, it needs to be novel. So your invention needs to be new. And the final point is all patent applications, they're filed with patent offices, and it's at these patent offices where a lucky patent examiner, they actually read your patent specification to try and understand how your invention works so that they can try and determine whether your invention is new. So that's the background information to patents. So when it comes to patents and patent protection, the most important thing, that's sort of the key, if you have nothing else to take away from this, the key thing to keep in mind is that when it comes to patent protection, keep your invention a secret, keep it confidential until you've actually filed for patent protection. And I'll show you why. So here we have your invention, and this is the day you first filed for patent protection. So when a patent office examines your patent application, this is when they're trying to decide if your invention is new or not, they'll actually search for publicly available material to try and prove that your invention isn't new. And they'll search through things like patent databases, Google, they'll use academic journals, and I've even had YouTube cited against us. But the caveat is they're only allowed to refer to material that was publicly available, so all this stuff, before the filing date of your first patent application. So that's why you want to avoid disclosing your invention before filing for patent protection. Otherwise, you can get into this situation. So here, you've actually publicly disclosed your invention before you filed your patent application. So maybe you started selling it, maybe you posted about it on Facebook. However you actually disclosed it, your own disclosure of it can be used to attack your patent application. And it can be used by patent offices, it can be used by your competitors to argue that your invention isn't in fact new and shouldn't be granted patent protection. And I've got an example of this to really drive this point home. So at our previous firm, we acted for a university that invested quite a lot in R&D and protecting an invention they'd come up with. But when one of their overseas patent applications, when it was examined, the patent office actually found a journal article published by the inventors 6 months before they actually applied for patent protection. And unfortunately, that journal article more or less disclosed the entire invention. And because of that, the university's patent applications effectively lost their value, and they eventually had to they decided to abandon their patent applications altogether. So when it comes to patents, this is really the key message. Confidentiality is really, really crucial. And I'll add that confidentiality is just as important for registered designs. So bear that in mind. Now, you can imagine there are going to be situations where inventions accidentally get disclosed. Sometimes the inventor just doesn't know better, which is fair enough. And thankfully, there is a little bit of leniency for these kinds of oversights. So some countries have what are called grace periods, where even if there is a public disclosure of your invention, if you apply for patent protection within the grace period, that public disclosure won't count against you. So for example, the grace period in Australia is 1 year. So if you file a complete patent application within 1 year of the public disclosure, you'll be safe in Australia. But when some people hear about this grace period, they're tempted to rely on it, and they might use the grace period as a way to find out if their invention has any potential without actually applying for patent protection. And this is a really big risk that I really want to flag, and I'm going to show you why as well. Now, firstly, lots of countries don't have grace periods. So if you disclose your invention before filing for patent protection, you can actually ruin your chances of getting protection in any of those countries. The second point is grace periods vary between countries. So Australia's grace period is 12 months, but Japan's is only 6. So if you were to wait for Australia's 12-month mark to file your patent application, you'd have lost your chances of getting protection in Japan. And the last point here is some grace periods are really strict. So for example, China has a 6-month grace period, but you can only rely on it if certain circumstances are met. So, and one of those circumstances, which I remember, is that your invention needs to actually have been disclosed by someone else and without your consent. So that's a pretty hard standard to meet. So while it's nice to know that grace periods exist, they're really a last resort type of safety net. You really, really shouldn't be relying on grace periods as your plan A. Now, the next couple of slides deal with a patent myth I would like to dispel, and I'd really like for you all to help me dispel because it just keeps popping up. Now, I don't know if you've heard of this myth before, but it goes something like this. The myth is that even if you protect your invention with a patent, someone else can just change your invention by 10% or 20% or some other figure, and they can get around your patent. We've run into a lot of people who have heard this myth, and they think that patent protection isn't worth it because they think it'd be pretty easy to vary their invention by 10%. Now, I don't know how this myth started, but the reason it's stuck around is, I suppose, there is a lack of understanding about how patents work. So I'm going to use this very simple example to show how patents protect inventions. So in this hypothetical world, this is sort of my example here. This is a hypothetical world where chairs don't exist and everyone relaxes by sitting on the ground, like this fellow. Now, I've got a chat icon. Yeah, he's searching for inspiration.
I'm not used to the person speaking checking the chat while they're doing it. Sorry, Warren, I'll stop doing it.
No, yeah, I could have sworn there was like an option. I remember there was an option on Zoom where like you could turn the chat off from popping up, but it's not happening. So that when I get that notification, I'm like, "Ooh, it's something really important. I better look at it."
It's really not. It's just me talking to you. Sorry.
Important.
No, all good. So yeah, we've got a guy sitting on the ground reading the Bible, and he's wondering, how do I relax better? And so let's say an inventor comes along, and they've come up with this chair. Now the inventor might think, what's the point of patent protection? Even if I protect this chair, I can think of so many other ways that chairs can be made. So it's going to be pretty easy to get around my patent in the first place. So why apply for protection? But that's just not how a patent works. So a well-drafted patent specification, so that's the document that describes your invention, it doesn't only cover the specific chair the inventors come up with. So I mentioned earlier that every patent application includes a patent specification, which describes the invention. So at the end of that document, at the end of that patent specification, there's a list of statements called claims. Now, the claims are very carefully drafted and written. They take a lot of thought because they define the invention and the scope of patent protection. And part of our job as patent attorneys is to write claims that are really broad in scope, and so that we try and protect the inventive concept you've come up with, not just how your invention looks on the shelf. So here's an example of a potential claim we might use if the inventors come up with a chair for the first time. So we might say it's a device comprising a surface for supporting a portion of a user's body above the floor. So, this bit here. And at least one downwardly extending support member associated with that surface and configured to engage the floor. So, maybe a leg. So here we have a claim that, sounds pretty strange, but what we've done is used really broad language to capture the essence of the invention. And in essence, the inventive concept of this chair is basically providing an elevated surface for someone to sit on, or an elevated surface which supports a user off the ground. So with that claim in mind, you can see that not only does it cover the inventor's chair, it also covers these other ones too. So if you look at these other chairs and read the claim, and you can ask yourself, okay, do these chairs have a surface for supporting a portion of a user's body above the floor? Yes. And do they have at least one downwardly extending support member associated with that surface configured to engage the floor? Yes. So that's basically how a patent works. And you can see that there's no 10% difference here between the inventor's chair and the other chairs that you can measure. So the take-home message here is there is no such thing as that 10% difference when it comes to determining what a patent protects. What a patent protects really comes down to the actual language used in the patent specification. So now that we've had a quick look at what goes into drafting a patent specification and the claims, I hope it's clear that the language used is vital, and perfecting that kind of language is something that can take years, even a lifetime to master. So all that is to say, filing a patent application without sort of professional advice, it can be disastrous. So in our experience, many self-filers, they often don't include claims. And even if they do, they'll write something like this. This isn't one I've taken from a patent application, but it is very close to a claim that I've read. Something like, I claim an innovative and new way of storing electrical energy in a more efficient manner. Now, this clearly doesn't define an invention, and it wouldn't be granted patent protection. Now, in addition to having good claims, for a patent to be granted, it needs to meet a whole range of requirements, and two of them are here. The first is the enablement requirement. So basically, the patent specification needs to describe your invention in enough detail such that someone else in that area of technology, in the relevant area, they can pick up the patent specification, they can read it, and understand how to put your invention into practice without much effort. The second requirement is the best method requirement. So basically, at the time of filing your patent application, your patent specification needs to disclose the best method you know how to put your invention into practice. And the problem is, in addition to not filing good claims, the self-filer is unlikely to meet one or both of these requirements. So, and here's where the issue kind of really becomes a problem, is that they'll file the patent application and then they'll start making public disclosures of their invention, all the while thinking they have pending patent rights, when in fact what they filed is essentially invalid. And the worst part is they generally won't find out that their patent specification has any problems until years later, when their patent application gets examined by a patent office. But by that point, they've already publicly disclosed their invention. And so they can't file a new patent application because that new invention or that invention that they file in that new application isn't going to be new over what they've already disclosed. But at the same time, they can't go back and fix the application they self-filed. So this is a situation where they've ended up publicly disclosing their invention, thinking they have patent protection on foot, when instead that was never the case. And they've missed their chances of actually getting patent protection. So the next issue I want to look at really relates to the patent application process. So typically, when you start the patent application process, you file what's called a provisional patent application. And this gets you pending patent rights in over 180 countries around the world. And it lasts for 12 months. Now, at the end of those 12 months, you need to file individual patent applications into each country where you want patent protection. Now, it's when you're filing into multiple countries around the world that costs can add up. And especially for a new business, those costs can be hard to prioritize or budget, especially if your invention isn't bringing in much revenue yet. The good news is there is a way to delay those filing costs by filing what's called a PCT application. And if you file a PCT application, you basically keep your patent rights pending for another 18 months. So if you file both the provisional and the PCT, you're effectively buying yourself a 30-month runway, during which you can refine your commercialization strategy, you can start earning revenue from your invention, and figure out exactly which countries your invention will do well in. So what you need to be mindful of, and this is something that's really important to keep in mind about keeping options open and which countries you can go protect your invention in. And I've got an example here to drive that point home as well. So we work with a client who thought he would only be commercializing his invention in Australia. So he decided to skip the PCT application. He saw it just as an additional cost and decided to file just in Australia. So, lost all these other countries. And since then, his invention has actually gained a lot of attention, and he's had investors wanting to partner with him and commercialize it overseas. But when they ask, whether he's got patent protection on foot overseas, there's nothing he can point to. And the worst part is, had he actually filed the patent application, the PCT application that is, he would still be within this 30-month runway right now. And so he could have told those investors, he's got internationally pending patent rights right now. So the take-home message here is, if you're unsure of your commercialization strategy, and if you're unsure about which markets or countries your invention is going to do well in, it can be very useful to buy yourself some extra time by filing a PCT application. So the final patent issue that I want to touch on, and it just relates to doing your own research. So patent protection isn't free. And it really helps to find out early on whether your invention is patentable in the first place. You don't want to be years into the process and thousands of dollars in just to find out that your invention isn't patentable to begin with. So the good news is there's a really good way to get an early indicator of how patentable your invention is. So after you file your provisional patent application with the Australian Patent Office, you can actually request that they do what's called an international type search on your invention. And the Australian Patent Office will come back to you with an opinion about the patentability of your invention. The international type search is relatively cheap. And one benefit is that if you end up going down the route of the PCT application, you can actually get some of this search fee refunded. And often it's quite a large refund. So yeah, that's my final tip for tonight really, is that if you want to find out if your invention is patentable, one way to do that for relatively cheap and in quite a reliable way is to get the Australian Patent Office to conduct this international type search. So that really brings me to the end of these slides. And these are the key points I want to leave you with. The first is that protecting your intellectual property can be a very effective way of carving out your niche in the marketplace. And we saw how Scoop Boot was able to do that. The second key point is when it comes to patents and designs, confidentiality is key. So if there's any doubt, keep what you're working on a secret until you've filed for patent protection or design protection. And the final point here is to seek advice early. If you only wait for an issue to pop up, so for example, someone's copied your product, or maybe you've noticed someone using your branding, but you don't have a registered trademark. If you only seek advice when those kinds of issues arise, it can often be too late or really, really expensive to fix. It's kind of like, the analogy would be kind of like applying for health insurance only after you find out you need it. So yeah, that really is all from me tonight. I hope you found it somewhat interesting, and maybe you want to buy that portable bath. But yeah, thanks for listening, and let me know if you have any questions.
Thanks, Warren.
That's fantastic. Thanks, Warren. How long did you have for questions?
1 minute.
Ask a couple and.
Yeah, maybe like half an hour.
Yeah, cool.
That should be hopefully enough.
Plenty, absolutely.
Half an hour. He will fill it.
But, I mean, I don't want to keep everyone. I don't want to keep everyone. I know you have dinners to go to and people to see. So, if you do have questions afterwards, just feel free to email me.